Welcome back to our channel. In today's video, we're diving into a crucial aspect of the American legal system, the duty of prosecutors to disclose exculpatory evidence, commonly referred to as Brady evidence. In this video today, we're going to explore some key cases, including Brady versus Maryland, Kyles versus Wheatley, and Napue versus Illinois, cases that have shaped this important legal principle. Good afternoon. My name is William Pernik.
I'm Ashley Cameron.
Ashley and I are criminal defense attorneys, and today we're going to bring to you a very interesting video that talks about what happens when the government cheats in criminal cases.
So first we're going to talk about a case I'm sure all of us are familiar with, Brady versus Maryland.
The Brady Rule, established in the landmark case of Brady versus Maryland in 1963, mandates that prosecutors disclose any evidence favorable to the accused that is material to guilt or punishment. This rule was born out of a commitment to due process and fair trials, and it emphasizes that justice must prevail over a mere desire to win cases.
I'm sure we all remember reading that case in law school. However, we want to talk a little more in depth about what it really means and how it affects our criminal cases day to day.
Brady versus Maryland is a super important case that stands for the principle that the government actually has a duty to provide to the defense any and all evidence that's material to the question of guilt or punishment and favorable to the accused. That means that in our system of justice, if the prosecutor is aware of something that hurts his or her case and helps the other side, they actually have a legal duty to turn it over. And when they don't, it could lead to people being falsely convicted of crimes and the prosecutor getting into some serious legal trouble.
And this can apply to evidence that directly goes to the defendant's innocence. It can go to weaknesses in the prosecutor's witnesses. It can go towards impeachment evidence or things that could affect the defendant's sentence.
It could also go into this gray area that we don't often get direct access to, which has to do with plea negotiations, what happens when government uses informants, what promises, what inducements, what leniency has actually been shown behind the scenes that could affect the person's credibility. Because just like you and I couldn't pay a witness to say certain things, the government shouldn't be able to overpromise them things and hide that from the jury.
Exactly. And the important thing that Brady versus Maryland and all the subsequent cases have really done is kind of force the government to have a little bit more transparency in the way that they're conducting their cases.
Now, one of the things that may not be obvious to a lot of folks is that in our adversarial system of criminal justice, prosecutor actually has a special role to play. And I think a lot of people imagine this system, Ashley, as one side being against the other, the best warrior from one side rides out into the field to meet the best warrior from the other, and they duke it out in front of the public, and justice is done somewhere in the middle. But that's not really how the system is set up, correct?
Correct.
And the reason for that is because a prosecutor has special duties. We don't always hear that, but the prosecutor actually, by design, is supposed to be a minister of justice. His or her role is to seek justice, not just convictions. It's unfortunately when life gets in the way, desire to win gets in the way, feelings, emotions, promises of lucrative career down the road, politics get in the way, that lines sometimes get blurred, and some people make really bad decisions and they could really destroy lives.
Exactly. And I want to go back to that point because all lawyers, we have an obligation and an ethical obligation to be an advocate. But prosecutors have that heightened duty. It goes just a little step further because they're not just focused on a particular client that they're advocating for. They're focused on the system, the state, the public as a whole, and that includes the defendant.
And when you look at case law, when you look at Supreme Court cases, when you look at appellate decisions that discuss duties of the prosecutor, those decisions all talk about how what's really important is not just that the prosecutor win, but that he or she win fairly. That because of the unique role they play in our system of justice, their job is to secure justice at the end of the case, and justice cannot be secured if you lie, if you cheat, if you hide evidence, and if you stack the deck in favor of your team, which includes law enforcement, and against the other side, because the defendant is oftentimes behind the eight ball when the case starts. When we get hired on a case, we do not know yet all of the evidence that has been collected. We're not privy to all of the information that the police have in their possession. And so unless somebody actually turns it over, you and I do not have a magical key to the kingdom. We can't go into the evidence room. We can't see what's in the evidence locker. We don't know what the police officer saw. We have to request access to view evidence. We have to obtain police reports that are provided to us. But if somebody doesn't write something in their police report, we may not necessarily know about it. If we don't have body cameras, and I think that's a huge, huge advancement in direction of transparency, frankly, if we can't see what happened, if we can't hear what happened, we have to trust that the other side is doing what they're supposed to do. And when they don't, that's when miscarriage of justice occurs.
Exactly. And another important thing to remember is Brady violations can occur in good faith. A prosecutor doesn't have to be, intentionally trying to hide something. Things can happen because they're busy, because they're overworked, because they didn't think something was important. But a Brady violation can occur even if a prosecutor thinks they're doing everything right. And that's where it's important that the defense needs to do their due diligence to ensure that, do we have everything? Have I asked all the right questions of the prosecutor? Is there anything that we can do to ensure that the prosecutor has done their ethical obligation?
It's also super important to remember that when we talk about the prosecution or the prosecution team, that actually is not limited to just the DAs or attorney generals who are prosecuting the case directly. This applies to police officers. This applies to investigators. This applies essentially to everyone who has been involved in a case under that lawyer, and it imposes an affirmative duty on the lawyer prosecuting the case on behalf of the people of the state of California or the United States to inquire, to go that extra step, and to make sure that not only do they build up the case against the accused, but also simultaneously disclose any and all evidence that could be material and favorable to the accused.
Exactly, because they have an ethical obligation to ensure that due process has been satisfied for that defendant, and that includes ensuring that there is sufficient evidence to convict, ensuring that an innocent person has not been wrongly convicted, and ensuring that the defense had everything that they needed to do to ensure those rights were protected. Prosecutors play a critical role in the American legal system. Their primary duty is to seek justice, not merely to obtain convictions. This responsibility includes ensuring that all relevant evidence, both incriminating and exculpatory, gets disclosed to the defense. So what qualifies as exculpatory evidence? This can include witness testimonies, documents, or any other evidence that may help prove a defendant's innocence or mitigate their culpability.
Now let's turn our attention to Kiles versus Wheatley. In this pivotal case, Mr. Terrence Kiles was convicted of murder in Louisiana. Kiles asserted that the prosecution withheld essential evidence that could have supported his innocence. This included witness statements and even police reports that were critical to his defense. The Supreme Court ruled in favor of Kiles, emphasizing that the non-disclosure or withholding of this evidence undermined confidence in the fairness of his trial, and reiterated that the prosecutor was required to disclose this information because it was fundamental to the integrity of the legal process and the defendant's right to a fair trial.
Before delving deeper into the implications of Kiles versus Wheatley, let's briefly discuss another important case, Napue versus Illinois. In this 1959 case, the Supreme Court dealt with the integrity of witness testimony. The court found that the prosecution's failure to correct false testimony given by a witness violated the defendant's right to due process.
The holding in Napue made it clear prosecutors have a duty not only to disclose evidence, but also to make sure that evidence presented in court is truthful. If prosecutors misrepresent or fail to correct misleading testimony, that could result in a violation of a defendant's right to fair trial, much like the failure to disclose exculpatory evidence.
Together, these cases underscore the crucial legal principles that govern the prosecutorial conduct in the United States. They reinforce the idea that a fair trial is a cornerstone of our justice system and that upholding this standard is essential for maintaining public confidence in the legal process.
Now, Ashley, these important legal doctrines we have discussed, they all sound good in theory. But what many people do not realize is that we've actually had an epidemic of prosecutorial misconduct that led to significant reform and even passage of specific laws.
Yes, California passed Penal Code Section 141, which actually criminalizes the government's violations of these important rights.
So if a prosecutor willfully fails to disclose Brady evidence, evidence that's material to the issue of guilt or punishment and favorable to the accused, if they intentionally, deliberately hide it, they can be charged and prosecuted with a felony.
And this can apply to deliberate concealment, destruction, or failing to disclose.
It could also apply to manipulation of evidence. There was, for example, a case where a prosecutor thought it was a really good idea in a child molestation case to edit the transcript of an audio recording, even though the original recording was provided, but he edited the transcript of the audio recording and then sent that over to the other side. Defense counsel on the other side didn't listen to the original, was looking at the edited recording transcript only, and as a result made some really bad decisions on behalf of his client.
This is obviously unethical behavior, which is why the state of California enacted these penal code sections. In addition to the penal code sections, there are also specific rules of professional responsibility that apply to prosecutors that specifically delineate their obligations as a minister of justice to ensure that they are upholding their obligations, to ensure that exculpatory evidence is provided to the defense, to ensure that there is sufficient evidence to pursue convictions for a defendant, and to ensure that an innocent person is not wrongly convicted.
They can't play discovery rules. And I can even tell you, Ashley, that one of the things that happened when a certain prosecutor I worked with was running for a judge, I actually got a phone call from a special committee that evaluates prosecutors and, I suppose, defense lawyers, and I was specifically asked, what is your opinion about this person's character? What is your opinion about this person when it comes to providing discovery? Have you ever had a situation where you felt this person was hiding information from you, not complying with discovery? And I didn't have any of those negative experiences, so of course all of my answers were in the negative. But it shows that they're really serious about eliminating this evil from our daily practice. But unfortunately, even with these rules that have passed, it still remains. And in fact, one of the research projects on your plate, I believe, is dealing with a prosecutor who failed to disclose to us evidence of a person's perjury arrests and perjury prosecution. So you can criminalize it, you can make it a felony, you can threaten to take people's license away, and yet you're going to still have some people who are either so deliberate or so unintelligent and so negligent in their duties that they're going to violate people's rights, fail to comply with their legal obligations, and not turn over this evidence just so that they can win. And that's wrong.
Which is why it's really important for defense attorneys to do their job. Prosecutors have this heightened duty, but criminal defense attorneys need to ensure that they hold DAs accountable for these ethical obligations. So we need to do our due diligence to ensure that we are thoroughly looking at our cases, having in-depth conversations with the prosecutors to ensure that we have all discovery and that we're actually holding them accountable and not just going through the motions.
I agree with you. And with that in mind, at the end of almost every video that we film, we usually try to bring people a helpful list of suggestions, tips and tricks, things you can do in order to improve your legal situation. And in the context of our discussion today, we want to summarize it for you. So Ashley, take us to number one.
So first, this may sound really simple, but reread Brady versus Maryland. I'm sure we all remember reading this in law school, but it's important that we don't just count on our memory of what these obligations are. We want to actually have a real working knowledge of what does Brady versus Maryland say and what are important recent cases or recent interpretations of these laws and how do they apply today.
Building on that, number two, I would say it's also important to understand at which point does Brady apply. We still have prosecutors who believe that Brady only has to do with disclosing evidence when you are about to begin a jury trial. But that's simply not the case. In fact, in the state of California, Brady evidence applies at preliminary examination, which means if you are a prosecutor and you're not providing evidence of your witnesses' convictions, of your witnesses' past misdeeds, of their examples of flawed moral character that you know about, and you're not giving it over to defense counsel so that evidence can be taken into consideration when the judge is making a decision whether to certify this person's charges for trial or not, this could lead to ethical violations, personal and professional sanctions, potential liability, and a reversal or a setting aside of a holding order.
And number three, understanding what the prosecutor's heightened duty is, making sure that you go back and read this penal code section, read their professional responsibility rule, so you understand not only what is a Brady violation, but what does that actually mean in practice that they have to do.
I agree. Number four, as criminal defense attorneys, we often practice opposite the same prosecutors in the same courthouse. It's very dangerous for people to get complacent, and to simply assume that the other side is doing everything that it's supposed to do. I like to practice what Ronald Reagan once coined the trust but verify approach. Have a specific checklist of all of the information that I must receive, send out informal discovery request in the beginning of my case, make sure I have every witness's criminal history, make sure I go through it with a fine-tooth comb, and make sure that I clarify, is there anything else in addition to what you have disclosed consistent with my request for information that you potentially may have failed to turn over? We don't have to accuse people immediately of deliberate misconduct. Sometimes mistakes happen. People can get busy. People can get overwhelmed. People can overlook something. But when you begin to see the same people making the same type of mistakes, when you have the same folks not disclosing evidence of the same types of crimes or background information that turns out to be really helpful to your client, then you begin to wonder, is this negligent? Is it intentional? And what are my ethical duties at this point?
Exactly. And building off of that, make sure that you review all of the discovery in your case, because I've had instances where a prosecutor has told me, yes, I've given you everything. There's nothing else. I've given you all the body cam footage and all the interviews. But when I've reviewed, supplemental police reports, I found, hey, there's this body cam footage that was taken on this date that I didn't receive. And again, the prosecutor maybe overlooked it or didn't realize that it was there. But again, it's up to us to make sure that we have fully reviewed all of the police reports and all the information that we have to ensure that everything is checked.
And Ashley, when you say this, I keep thinking back to the couple of times that it happened when this last, small, likely irrelevant piece of information wasn't given to me until the 11th hour. And when I looked at it, almost each and every time I found some significant value in it. It may not always be the smoking gun, but it could certainly lead you to question where the smoking gun is, who held the smoking gun, and why wasn't it provided to me earlier in the case?
Exactly, and that brings us to our next point, that Brady violation doesn't just mean failing to disclose evidence, it can also apply to the timeliness. So maybe the DA provided it to you and then they're thinking, hey, I've satisfied Brady. But providing something to you that late in the game can be a Brady violation because that can affect the defendant's fair trial and their sentencing and the way that their case proceeds.
Right. If you hand me a police report that shows that your chief accuser was lying and you give it to me after my client was convicted at trial, that's not going to do me any good.
Not helpful.
Not helpful. And if you provide it to me after my client was held to answer at the conclusion of preliminary hearing before the trial, but you've had this rap sheet and you've been sitting on it all along, not useful, unlawful, unethical.
Exactly. And our next point is don't be afraid to use appellate procedures. Like you said earlier, we practice in a lot of small communities. We deal with a lot of the same DAs, a lot of the same judges, and sometimes we maybe want to feel like we don't want to rock the boat too much. But we need to remember that we really want to ensure that our clients' constitutional rights are upheld and that prosecutors are held accountable for their ethical obligations. So using your appellate court procedures to really ensure that your client's case is being treated properly is a great tool.
And finally, in establishing a Brady claim, it's super important that you document absolutely everything that you have done. When you look at our files, for example, we document the date when we send out a request for discovery, usually right after we get retained. We document every follow-up email that we have sent out, following up on, hey, where's the statement from so-and-so? Where's the body cam from officer such and such? You want to document everything because good record is what helps you establish a good case for a dismissal, for sanctions in your motion. And if you fail to have good record, if you are just shooting in the dark, you're much less likely to be successful.
And a lot of conversations can happen in court or can happen over the phone. So always remember to send that follow-up email memorializing what that conversation was so that you do always have a written record and things that were said or not said in person or phone conversations aren't lost.
Or at the minimum, make a file note so you will remember what happened. You will remember what discussion was had. And that can sometimes go a really long way.
Exactly.
We really hope you enjoyed watching this video. This is a very important legal doctrine that makes a big difference in our courts. If you enjoyed this video, you would like to see more videos like it, please click like, please subscribe. If there's something in what we have discussed that sparked your interest, please feel free to shoot us a comment. We love engaging with our audience. We'll be sure to respond. Until then, stay out of trouble.